Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer Podcast. Thomas Vick here. Co-host Seth Wilson also here. Seth, how's it going today?
Thomas, we're doing great. It is graduation season for my household. So I'm heading to a college graduation this weekend. Pretty excited about that.
Absolutely.
And, it's a new era for our family. We've got three kids in different stages of life. So we'll have a college graduation. That'll be the first time that's happened since, family members and our graduation. So a lot of fun memories there. Will be a good time for our family. How about you?
Congratulations on that. I know that's exciting and lots of planning happening along those lines. Things are good. Just moving right along, day-to-day work schedule, family life is good. So yeah, just moving right along with everything. We're kind of talking about what to discuss during our episode today, and we thought we might discuss the topic of what to do when you have to tell a client bad news. Unfortunately, lawyers aren't magicians, and sometimes we have to tell the client that things didn't go your way, and it might be due to circumstances that happened before the attorney got involved that the attorney really can't control. Sometimes things just didn't work out. Maybe a hearing didn't go the right way, and we got a court order that didn't, say what we wanted it to say. Maybe a negotiation isn't going to go the way that we wanted it to go. So lots of different scenarios that we could maybe bring up in the conversation, but the overall topic today is how to communicate bad news to a client. What are your thoughts, Seth?
Well, I love how you just tee it up and then throw it over to me to try to answer
You're welcome.
this difficult
Yeah.
question, but it is so important. It's such an important aspect of being an attorney. And also, when you're running a firm, you're going to inevitably run into these scenarios where things didn't go as planned. And that could be from the case perspective, it could be from a billing expectation. And so you're going to have different scenarios that come up, and the bad news piece is really important. And so I think one of the most important discussions that you need to probably have thought through even ahead of time is what is your timing going to be when you get that bad news? And we've talked before kind of how Indiana does that from the court perspective in terms of sending out court orders, and they process them overnight, and they typically get sent out in the early morning hours of the day. And so I may not get notice of an order until a day after. It's possible that my client has actually seen the order on the court's website the night before and already has an email in my inbox by the time we get going the next day. And so timing is really, I think, one of those important things. And there's a lot of nuance to that. My general philosophy is bad news doesn't get better with age. And so if I have good news or bad news to share with a client, I try to get it to them right away. But that's a general rule, and there's always exceptions to that. So what's your approach on that?
Well, my approach is, first of all, knowing the client, knowing kind of what's going on in their life. And, sometimes the bad news can wait a day or two. There may be situations where, it might be the passing of a loved one has recently occurred. And so that's really top of mind for the client. And whatever I might have going on is still really important, but it could wait a couple days, and then I can communicate to the client what's going on. So if you're aware of some of the personal affairs that are happening with the client and kind of the stress levels that they have, then timing can really impact how well or how poorly certain news is received. And so I try to be aware of that. There's always the obligation to communicate the bad news. It's not like you're trying to avoid the communication of that bad news, but you just want to be a little bit wise when it comes to communicating that as far as the timing is concerned. Along those lines, though, is if I can be ahead of the bad news before my client finds out about the bad news, I feel like I can steer that conversation in a way that the client is going to have more of a measured reaction to the news rather than, if the client finds out by himself, then, he may be coming to my office fighting mad, wanting to know what's going on. But if I can say, hey, I got something I need to talk with you about, things didn't go that well, but this is kind of what I expected. And if you can understand the reasons why the decision was made or the result was had the way that it was, if you can understand the reasoning and then you explain that to the client and you're the one that's really first providing that news to the client, then you really are going to be able to control that conversation. That's what I've always tried to do is, prep the client first for the possible bad decision, get the bad decision, and then communicate again the reasons why we got the bad decision or the bad result. And then the client can kind of at intervals start to come to terms with what has actually happened.
I think it's such an important observation, Thomas, to be aware of the situation. And you can make a bad situation a lot worse by piling on, the hits just keep coming. And you have an opportunity to hopefully cushion the blow a little bit when that discernment is allowed. There are sometimes you just gotta, I think you used the phrase, rip the band-aid off and just, hey, this didn't go the way we wanted it to, and we're gonna have to deal with it. But there's also times to say, you're in the midst of so many other more important in the grand scheme of things issues. Let's wait and address this one when you're at a point to be able to receive it and even process what I'm telling you. Because right now you may not be able to think about the implications and or be ready to handle that. And I think that piece of the puzzle is also very important to understand, like, hey, we've got to work through this issue together on a time frame that makes sense, and we need to be able to have the conversation. So I want to prep you and say, hey, this is coming, but I also want to create some space and time and opportunity to sort of grieve that loss. And I often use the analogy of the 5 stages of grief. And that's very true in a lot of micro level, all the way up to macro level type issues. And so, you stub your toe, you're going to go through the 5 stages of grief, right? It hurts. You have that anger, that instant response, denial. I can't believe I did that. I'm so clumsy, all the way through bargaining, depression, and acceptance, and all those things. And so creating that space and that runway to say, hey, we don't have to make decisions about the bad news right now, but I wanted to get that to you so we can start that process. Let's talk in a day or so and kind of figure out what the next steps are or what this means in light of everything else that we have going on in this scenario.
Yeah, you're mentioning the 5 steps of grief. Kind of makes me think of just how clients are in general with a stressful situation on their hands. How do you talk to a client that is experiencing a stressful situation? I do long-term care planning, Medicaid applications, where a loved one is in the nursing home and you've got bills that are coming and their loved one's health is going poorly and they're kind of at a loss for what is going on. So it's a very stressful time in life for individuals. And in my mind, I can kind of see the path that they need to travel before they've even thought about setting foot on the path, really. And, I can walk them through that step by step. But my feeling on it is, I used to be, I'll just be long-winded and I'll say, you got to do this and this and this and this and this, and I talk for 30 minutes in the consultation. But more and more, I just want us to focus on this one first step that we have to take. Do we have a power of attorney in place? Okay, let's get that power of attorney in place, and then let's revisit our conversation, and then we'll go from there with planning that needs to happen. And so you could apply that to any other kind of facet, any other area of law. If you're in personal injury, you have that consultation and the client is already thinking through, I'm going to win before a jury trial. The client really just probably needs to be focused on, this is what I've got to do. I've got to, I got a deposition that I got to go to, or you just stay focused on the moment and try to keep your client focused on that rather than letting them extrapolate everything out, because that's really where the stress comes. It starts to build and build and build the more events that they can kind of foresee. And if we can just stay focused on the short-term problem and let the attorney kind of have in the back of his head the long-term problem, I think that's a good way to handle client conversations.
Yeah, and it's especially appropriate when you're talking about the receipt of bad news, because the hope meter has to reset. We hoped this outcome would happen or not happen, and it did. And now, what do I do if I'm the client? And the lawyer's probably asking the same question. What do we do, right? How do we handle this? And so, having that conversation at the appropriate time. And I think that kind of brings to mind another point that might be important to put into place in your personal practice is, before you do just pick up the phone and give the bad news, you want to give some thought to how you're going to relay that conversation. I use kind of a phrase I call the bookends. I want to know how I'm going to get into the conversation, how I'm going to start the difficult discussion and relaying that bad news, and how I'm going to end it. And so the stuff in the middle, I'm not exactly sure. I'm not going to have quite outlined or thought through necessarily, but I want to know how I'm going to get in and give some hope on the back end in that plan of, hey, this isn't the end of the world. This just means this reality, and here's what we do next. But try, like you say, to kind of bring a little bit of closure around that particular focal point rather than every eventuality that may occur. Because when you're upsetting the plan that was in place, now all possibilities are back. And so we've got to address that and help clients navigate that again as the lawyer, saying, okay, here are the options. And hopefully there's another good option available, and you can work through that as you go through the process with the client.
Yeah. And I think that's really good. And I think I keep coming back to the idea of prepping your client for potential bad news. And I think that's a really tough line to walk sometimes, because when you're prepping the client that bad news may happen, it almost makes it seem like you're not confident in your actions. And so you gotta, that's a tough one. You want to exude confidence before your client. They're trusting you to solve the problem, but hopefully in the rapport that you've built with them, they begin to trust you and trust your legal advice, your legal expertise on a particular matter, and demonstrate to them that you can guide them through that process. I think that's the main thing, and I think that's what you're getting at, is demonstrating a path demonstrating a path forward for the client to take. And that's the way to go with those conversations.
Yeah, and preparation, I mean, that starts at the front end of the engagement or the relationship with the client, in terms of, hey, we're working through a process together, and I'm going to share with you my experience and thoughts about what's going to happen along this journey as we get to them. And I want to make sure that you recognize that there are risks involved along the way. And yet I'm going to hopefully have built the trusted advisor role to the point that what I'm telling you both makes sense, and I've already sort of taken the surprise element out, because here are the factors that are going to influence the decisions in this case, and they may not be all in our favor, or they may come with a certain level of reality that we're going to have to address. And sometimes that's going to happen at the most inopportune time throughout the case. And that's often the case, I think, we find in our particular practices in estate planning and probate work and trust administration, because the circumstances of the plan change midstream. Someone's health takes a different turn than we anticipated. Someone passes away unexpectedly. There's so many different variables that can go into that. And so I think keeping that focus, like you mentioned, and paving the way from the outset of the engagement with the client as to what is needed to know, help balance that confidence with reality, what's sort of a anticipated risk or a reasonable risk within the representation, what's in my control, what's out of my control. All of those things can go into that decision-making process.
Speaking of things that are not in our control, I think prepping clients for court decisions and the timing of those court decisions is something to be careful about. Client may hire you to file a motion in a case that they have. How quickly can the client expect a decision on that? In the family law context, you may have like a preliminary hearing, and then you might have multiple hearings after that. It could be a several month long process before a decision might actually be made. But the client might have the expectation you're going to file this motion, and then bam, you're going to get a court decision within a week and everything's going to be fine. So expectations as to timing in litigation is, I think, really important to keep in mind and set before the client. Courts have their own dockets, so you're not going to be able to just step into the courtroom and immediately get a decision. You got to work through the process. They're going to set a hearing, 30 days out a lot of times. And so you just have to prep the client for that kind of thing too.
Yeah, and that's another kind of bad news that may happen in a case. You had a deposition or you had an event scheduled or a hearing scheduled, and due to the court's schedule, due to opposing counsel's schedule, one of the parties' schedule, that plan changed. And so the client thought, hey, once we get this done, that leads to the next step, which means we're going to get this result within 30 days, 45 days. And now we're talking about another 6, 8 months. And that's another kind of bad news to help navigate. And again, it goes back to, because this is a new process for many clients, there's no experience base to say, oh, this is normal. This isn't unusual. For the lawyer, you've done it for a long time, and that becomes the normal routine. You have to take what's normal to you and break that down and explain it to the client so they understand nothing's wrong with your case, but these situations have occurred, and be willing to help them navigate what is undoubtedly going to be some frustration because expectations keep moving. And it's a bigger picture question because, well, this isn't just, and we're in the justice system, and why is this happening, and why can't we get justice for our case? That's what this is supposed to do, and you're a lawyer, you're supposed to make that happen. So you're dealing with multiple levels of potential frustration there, and you want to make sure you're addressing that level with your client. And I think the more you go through these conversations, the better you get at identifying what's really the issue that they're struggling to understand. Is it their case? Is it a financial concern? Is it this just isn't right societally? We should have something different in place, and all those questions that can come to mind. And so trying to help navigate, and I think that's where the phrase counselor at law kind of came to be, where you're also helping process a lot of these decisions and interruptions, if you will, to the outcome of the case.
A phrase that has always been helpful to me when there has been a delay in some legal problem that a client is going through is, the wheels of justice turn slowly. Keep that in mind. Put that in your bag. It sounds really good, and clients just seem to get it. And they're like, oh, okay, yeah, I really am in a court case. This is the way that it works. That little truism sometimes is helpful. So maybe people can use that.
Yeah, I think that's a great reminder of, this is a long process oftentimes. I often say nothing in the law happens fast, and the best we can do is a reasonable time. But even opening a file sometimes in the office takes a little while to get something open and get work on. And I know that's more of a challenge if you're opening up a new case or a lawsuit with the court, or if you're opening up an estate or a probate administration with the court. It takes time. It takes days sometimes to do that. And that expectation adjustment is so helpful to say, hey, it's going to be okay. We're going to get there, but it's going to be a longer process than you probably thought or wanted it to be.
Yeah, I think that's a lot of good stuff there to keep in mind. So I guess we don't have the perfect answer for how to handle difficult client conversations and how to communicate bad news to your clients, but maybe those are some pointers that you can take and apply to your particular situation and um, see if it works for you. I guess if I had to summarize from my standpoint, be ahead of the game, know the news before the client knows it, have grace in communicating the bad news, and think about that conversation before you have it, and have a solution that you can provide to the client if there is one possible. They can kind of point you to the next step.
Yeah, that's a good summary, Thomas. I think about the fact that we're all humans and you got to be aware of the context when you're delivering the bad news. And then you got to be willing to sit in that a little bit with your client and help them process it. So I often will advise, don't just send an email, pick up the phone, set a meeting, whatever the right context is for it. But it can look very abrupt if you send an email with the bad news. There are ways to do that, to say, hey, I wanted to get this to you right away. It's not good news. Let's talk when you have a chance, in the right context, knowing who your client is and what their familiarity is with the situation. But I think most of the time that phone call, at least in-person meeting, probably is a good thing. So you can see each other face to face. They can see that, hey, this is affecting you as well, and you take it seriously and you're concerned for them. All of that, though, you still have to obtain and maintain your objectivity as an attorney. And so your last point, I think, is really good, that you have to have processed it enough to be ready to handle that conversation and give a pathway forward.
I appreciate the conversation today, Seth. I encourage everybody that is listening to check out lifetimelegacylawyers.riverside.com. That's our website. You can check out all the videos and episodes that we have up on that website, and go to youtube.com and find us on the Lifetime Legacy Lawyers channel. We got a ton of videos up about law office management and how to start your law practice. So we encourage everybody to go there and check those videos out. Seth, anything else that we want to add?
No, just comment on the YouTube channel or send us an email, Seth@lifetimelegacylawyers.com or Thomas@lifetimelegacylawyers.com, with any questions or thoughts that you have, or things that may have been helpful in your practice or your experience in delivering bad news to clients. So, Thomas, thanks for the time today, and we'll see you on the next one.
Thanks, everybody.